disputes uniquely challenging. And this is, as you know, part of London International Disputes Week. We're grateful today to Baker McKenzie for having us here. And I must say, it is absolutely wonderful to be doing proper in-person events again, and so good of you to turn up in person. And thank you to those many people who are also logged in via Zoom. And a quick word of thanks to our sponsors. Alex Partners and Ancora are the platinum sponsors, and the many other generous sponsors who are on the screen. Just before I go into sort of introducing us, I just want to say, if at any point during the session you have questions, please don't hesitate to stick your hands up. We're happy to take questions throughout, but there will be another sort of 10 or 15 minutes at the end to take questions as well, if you prefer. Anyway, without further ado, I will introduce myself and ask my panel to introduce themselves as well. My name's Arabella Murphy, and I'm a mediator through IPOS. And so in this session, we're going to be focusing, as I say, on offshore trust disputes, and I'm lucky to have a panel of experts in this field. Charlotte, do you want to kick off with introducing yourself?
Hello, everybody. I'm Charlotte Fraser. I'm a partner in the Contentious Trust and Estates team at Fraser in London.
Well,
everybody, I'm Will George. I'm a managing associate in the commercial litigation team at Addleshaw Goddard.
And hi, everyone. I'm Luke Richardson. I'm a senior associate here at Baker McKenzie in the dispute resolution team.
Great. And as we know, all litigation is complex and challenging in its own way. But when offshore trusts are involved, there are some unique features, we think. And in this session, we're going to go through some of those issues, including thinking about coordinating and the practicalities of having a multinational legal team involving at least two sets of lawyers in different jurisdictions, and the challenges that can give rise to. One unique feature of trust disputes is often that you ask yourself what's really going on. Often it is there are perfectly reasonable legal issues, but there's also perhaps underlying family disharmony and other issues which are going on behind the scenes, and you need to learn to separate those. Thinking also about how to mitigate the fallout, particularly if there's a business involved, and also for the family themselves. And thinking, as I would as a mediator, thinking about mediation and the particular push and pull factors for very wealthy families, families with a high profile, what can lead them or not lead them to sit around a table. And can it actually settle? Because there are also often there's trustees, there's minors, there's unborns, there's future spouses, all sorts of different interests which we might not have in other kinds of litigation. And that can affect the outcome both of mediation and also be a factor at play in the outcome of proceedings themselves. And finally, and obviously importantly, given this year's theme of global, sustainable and ethical, we think about the use of technology and how much we've become accustomed over the last couple of years to virtual trials. And we just have a think about, in the context of trust litigation, whether that's something that will continue into the future, or whether we're looking at some other different model. I'm going to start by asking Luke. We're very lucky to have Luke on the panel because he has just been involved in the extraordinary case of Grandview and WONG. And Luke's going to give us a quick overview of that so that we can then use that and pull those themes out of that case as a real example.
Thank you. So WONG is a fascinating story, but it will be one that's got very familiar features for lots of people joining today. It involves a patriarch who was born into very poor circumstances in 1917, I think. But over his adult life, he built up a very wealthy and very successful business. So by final years of his life, he was one of the richest people in the country. He also had lots of children by lots of different women. So he was a very busy man. And in particular, he developed very particular ideas about wealth and how to use wealth and how to preserve family wealth within for the generations to come. And he subscribed to a proverb that I think is quite common in Chinese societies, which is where he lived, but also around the world. And it's this idea of rags to riches to rags in 3 generations. So it's this idea that you can't keep money in the family forever. Eventually, it's going to go to the tax man, or it's going to get divided into infinitesimally small pieces, and it's just going to go. So he was very interested in finding a way to keep the family legacy going forever. Unfortunately, he died in 2008 without leaving a will and without leaving any detailed instructions to all of his children about what to do. But it turned out after his death that in the final years of his life, when he was in his 80s, he'd asked some of his children to work on a structure for the family wealth, which was mostly shares in the family businesses that he hoped would endure for generations. And he said to them, I want my family to be able to benefit from this wealth, but not freely. I want them to benefit in a controlled way so that the money and that the family influence in the company can survive perpetually. And the device that the children put in charge of this task alighted upon was a Bermudian non-charitable purpose trust. So it's quite a novel concept at the time. It was introduced in Bermuda by statute in 1989. It's a trust structure which has no human beneficiaries, but exists for an array of purposes that are specified in the trust deed. They don't have to be charitable purposes. It can be anything that we'll see. We'll see whether you can have anything, but you can come up with a range of purposes that you want. For example, the purpose of this trust will be to hold shares in the family company and keep the family companies going forevermore, which is a structure that they come up with. The big problem with that is that you can't then extract money from those trusts to benefit the family. And of course, by the time the father died, all this money was in the hands of these children who'd been chosen to set the structure up, and the rest of the family were completely cut out of the structure. So unsurprisingly, litigation has been going on ever since. It culminated in an 80-week trial that was due to take place in Bermuda in 2021, last year. It was due to take place in person, obviously in the middle of the pandemic for most parts of the world, but Bermuda had until then been relatively unscathed by the pandemic. So we all flew out there, got set up. We'd constructed a courtroom big enough to fit all the lawyers involved in this hugely valuable case. The trusts are worth billions. And then they had an outbreak of COVID, and at an emergency hearing, the judge ordered a virtual trial, and we were all put on planes and sent back to this very floor in this building, where we then spent the next 80 days conducting the trial. So that's the sort of interesting technology angle that I think we can talk about in a bit more, that sudden pivot from a traditional in-person trial to a virtual one.
But you haven't had judgment yet. That's awaited.
Yes, judgment any day now, I think, but no sign of it yet.
Fantastic. Anyway, as you have probably got a small flavour of how fascinating that case was, similar in some ways to cases that many of you may have been involved in the past. I think quite often family trust litigation does have common features to it, but the particulars of that case were so extraordinary, given that you ended up managing the trial online. But I think the first and most important bit that I want to pick out of that as a sort of a live example of how this works is you've got at least 2 sets of lawyers in different jurisdictions. And I mean, it gives rise to lots and lots of different questions. I mean, the first and most obvious point is perhaps from the client's perspective, that looks and feels like 2 sets of costs. But actually, I think from a lawyer's point of view, it must be quite interesting how you manage that team, who leads, how you construct your team, how you coordinate the advice and the workload. And Will, I'm going to come to you on this because I know you worked offshore for many years, so you've actually got the flip side of this, as well as now being back in England. But so you've got both perspectives.
Thanks. Yeah, I have. So I worked offshore for a number of years, and working onshore work in a number of matters with collaboration between onshore and offshore practitioners. And I think the first thing I'd say is that there's a risk in presupposing that either onshore or offshore leads to use that term. Obviously, the client is going to have their trusted advisor, and naturally somebody within the framework of onshore and offshore will have to be the final decision maker. But in my experience, the real value between onshore and offshore is collaboration. And when I say collaboration, I mean true collaboration. So I think it does a real disservice to offshore, which, you know, for those of you who've worked there or been there, that offshore jurisdictions generally allow very sophisticated court systems, judges and lawyers that have all worked at firms like this and really have a lot to offer. And the way you collaborate with real value, I think, is rather than presupposing or coming up with a mechanism that might work in this jurisdiction and then asking the offshore law firm to deliver that process for you, is to really sit down and explain the nuance of the dispute and the client's desired outcome, and then work together to understand, you know, if you have 20 options onshore and 20 options offshore, between the two firms, what really would be the best option for the client. So I think that approach is, you know, what I tend to push for, and I think is the best outcome. And I think that, you know, that the flip side to that coin, kind of the thing I would urge everyone to avoid is the kind of, for want of a better phrase, the postbox approach, where a firm might try and do everything onshore and then deliver a bundle offshore and ask them simply, you know, give you back a Norwich Pharmacal, for instance. I think you've similar to me, you've worked onshore and offshore, so perhaps you can.
I've only worked onshore, but actually I've been involved in a number of cases where we've worked closely with offshore lawyers for an extended period of time, and I've used the postbox model and the non-postbox model. And I can absolutely say with confidence that the collaborative model is the best model, not just for advancing the case, but it's absolutely in the best interest of the client in terms of delivering not just a seamless service, but ensuring actually that from day one, their objectives are understood by everyone on their team. Because I think so often it's easy to come up with a strategy that you know fits the client that you've come to know and understand, and then you discuss it with the offshore lawyers who've got a completely different perspective on it in terms of how things are playing out in their courts at any given moment in time. I do think one of the biggest issues then with clients is explaining to them that they're not paying for two sets of teams and they're therefore not paying double. And I do think that managing client expectations from day one is hugely important. And I think a lot of work needs to be put into that from the sort of the lead lawyer or the trusted advisor. And I think actually one of the key selling points is that you can say, actually, ultimately, I think it's cost saving, because if it's properly managed from day one, the offshore lawyers understand not just the underlying facts, but they also have an opportunity to get to know the clients and understand the emotional drivers behind the case and the personalities involved. It just means that from day one, everyone is on the same page and understanding ultimately not just what one might want to achieve in any particular procedural hearing, but actually at the end of the day, whether that's in mediation or at trial. And so I think it's really making sure that clients understand that just because they're getting fee notes from two different firms, that it's not necessarily increasing their costs overall. And the other thing I would also say is that I do think technology has made it so much easier for clients to get to know the offshore lawyers in a more meaningful way from an early stage. They're not just sort of names on screens or at the bottom of emails, but actually the fact that they can have video calls and actually really collaborate with them and get to know them and potentially also open up to them, I think is really helpful. But I would also say from the lawyer's perspective, as far as interlocutory or procedural hearings are concerned, before, as the onshore lawyer, things might unfold in court in an offshore jurisdiction, you're sort of told the outcome, but don't necessarily understand the nuances of how it developed and what arguments did or didn't make an impression with the judge at the time. Now that it's possible to attend those hearings virtually, not always, but in many cases, I do think that just makes the onshore lawyer's job that little bit easier in terms of understanding what's working and what might not be working in that jurisdiction and why. So I think things are moving on in a positive direction, but I do think there's still a bit of work to go.
And is it your experience that there is normally, in reality, one firm or another that's driving it? Where does that come from? Because probably at some point there has to be a decision maker.
I do think that's the case, but I don't think it necessarily needs to be the offshore or the onshore lawyer. But I think it would be unrealistic to say that most clients don't have a lawyer with whom they have the sort of the closer relationship and regard them as the trusted advisor. The pressure is therefore on that person to ensure that they bring other people into the conversation and don't sort of take advantage of that position for themselves. But actually, this is an important conversation. I think it's really important that this particular lead partner in the offshore jurisdiction joins us just to thrash this idea out. And I think they have a real responsibility to the client to ensure that collaboration happens at every level. But I still think that there's probably, in most cases, one person that the client tends to identify with, in my experience.
It's so interesting. And Luke, does that reflect your experience on Grandview? I mean, is that how it worked in practice with the multitude of different legal teams?
Yeah, I think so. I think, you know, in a large, high-value international case, almost by definition, you're going to have lots of different lawyers involved, coming from different perspectives with different areas of expertise in different parts of the world. And there's a sort of a tension between making sure that everyone's particular expertise is properly utilized and not having too much sort of chaos where you can't really make decisions and the client asks a strategic question and you're presenting 10 different viewpoints and he doesn't know what to do. You know, so part of the job of all of us is to sort of make sense of that for the client, right? So you don't want to be shutting people out and making sure that important views aren't heard, but equally you've got to sort of present a coherent picture that the client can understand. And I know that in lots of certain offshore jurisdictions, I think the onshore firms, you know, headquartered in London and US, I think historically they have had a bit of a bad reputation, sort of running these cases a bit too much from their own silo and not, you know, recognizing the fact that they are litigating in the Cayman Islands or the BVI, and you know, it's a particular court process with particular strategic considerations that you've just got to pay attention to. You just can't run it like a London case if it's not in London.
And that key theme of using offshore firms as if they were counsel is not really, not at all the most helpful way forward.
It's not in the client's interest.
Yeah. And Charlotte touched a little bit on this, but also you highlighted it. The use of technology in WONG, how did that actually help things run more smoothly?
Yeah, I mean, before the decision to go virtual, we were already using like a cloud-based trial management platform. You know, lots of big cases are using those now. There's nothing that novel about it. You know, the benefits are quite well known. You've got all the documents online, all the disclosure, all the witness statements. You can put your comments on there that other members of the team can read. You can tag the issues, synthesize the information quite easily. And of course, you're not printing off reams and reams of bundles every time. And I guess I'd say importantly as well, you can access it from anywhere in the world. So in a case like WONG, that's really important because you've got everything in front of you whenever you need it. So I think that made the sudden halt to a remote hearing a bit less painless than it might otherwise have been. And then of course you've got added benefits as well. And one I particularly found was just having all the counsel in the same room where they're sort of, you know, they've got the judge, which is a computer screen there, and they've got the solicitors sat behind them, all working in the next room quietly, and you're able to communicate with counsel very effectively. You can either talk to them on WhatsApp, you can talk to them in person when they're, make sure they're on mute, and you're not sort of passing post-it notes back and forth, like you're grabbing onto their coattails if they're sort of presenting in court. And I found that stretch that out over 80 days. I found that to be a real benefit, I think, and all through the use of technology.
And another point that stands out in the WONG case is one that's kind of common, as I mentioned earlier, to many trust disputes and other kinds of family disputes. And that is this sense that although there are legal issues, clear legal issues at play, there's also that underlying family tension or disharmony. You wouldn't be there if they all loved each other dearly and weren't disagreeing about anything. So there's kind of two layers going on. And talk to me a little bit more about that idea. How did that manifest itself in WONG?
Yeah, I mean, I think in lots of these cases, ultimately, there's a family grievance at the heart of it, and it might be something that's gone on many years ago that sort of bubbled under the surface, and then some catastrophic event happens. You know, someone dies, or there's a divorce, or there's some other problem, and then all these things come to the surface. And I think, you know, as a lawyer, you've got to be able to understand the family story, because you might one day be presenting it to the court, and you've got to be able to do that in a persuasive way. but also you've got to be able to pick through the family drama and identify the legal issues, but also identify the key points that are important to the client, and in order to be able to give him advice on what he or she needs to hear.
And Charlotte, I mean, how does it make the work of the legal team more challenging or more interesting in this kind of case as opposed to other kinds of cases?
I think it makes it a lot more interesting. I probably would say that, but I think it also makes it less predictable. I think one can be presented with a set of facts and a team of experienced lawyers who can analyze the documents and tell you what the legal arguments might be and what the legal strategy might therefore look like. But until you've got to know the clients and the personalities, you really don't necessarily know how any of your proposed strategies are actually going to play out. And more often than not, it's the relationships between the clients that really count. And this is where I think so often it happens that clients can give you insights into how a strategy is going to play out that end up being absolutely vital to the outcome of the case. And so I've got one on at the moment where, there's a patriarch and we act for his children, and you can see that they understand their father and how the power plays and the dynamics might actually work out. And by listening to them and how they think particular arguments that we might set out and what we think is innocuous correspondent are then going to be perceived and analysed by him and his team, can actually have a really significant impact on whether or not we're going to be able to break a particular impasse, or whether we think that an isolated comment of no significance is actually going to be a real thorn in his side. And so it's really vital that you actually listen to your clients, because I think their insights have really got to form a part of the strategy. And that is impossible to predict at the outset. You just wouldn't necessarily know what the dynamics are. It's very sort of easy to think that it's sort of typical, but we all know that no family, whilst there might be themes, no family is the same. And so I think that's why every case that we do is different and probably a lot more fun as a result.
And I guess actually, Luke, part of it must be, particularly when dealing with international families, there must be some cultural issues as well at play there. So not only in this instance, do the children are the ones best placed to understand their father and his likely reactions, but there's a cultural overlay on that as well.
Yeah, I mean, I completely agree. Every family is different, and you can't sort of treat each case like you treated the previous case. But yeah, I think part of it as well is educating yourself about the particular cultural background, because that helps you understand the facts and the disputes and why feelings are so high. But also, the way, for example, a Chinese family might approach dispute resolution is very different from how a Venezuelan family might approach dispute resolution. So there's all these sort of cultural nuances that you don't find when you're sitting here in London and you've grown up in the UK, as I have, and you've got to just learn them and understand from the client and build up that relationship of trust with the client, where the client feels like what language they're speaking, both literally and metaphorically.
And I guess, I don't know, Will, from your experience, is that where trustees can help in some ways? Because the involvement of a trustee at least gives you a sort of a third party who can, in many cases, take control of the proceedings by making it an application for directions, for example, rather than head-on litigation between family members who are in dispute. What's your experience here? Does that help or not always?
I mean, I think there's always, in the type of work that we all do, the first consideration is jurisdiction by jurisdiction. There's sometimes challenges around a Beddoes type application where the court's asked by the trustee to determine essentially a dispute between beneficiaries, and that's always a consideration. But that, notwithstanding that, I think that the broader point goes to the points that have been made very well, in that the court can only dispose of the issues that is presented in a proceedings. And the reality, in my experience, of a lot of these family trust type disputes is that the dispute that we're instructed to deal with is a manifestation of something much bigger. And actually, if a trustee, even if a trustee were to be successful in obtaining some form of declaratory relief that resolved a particular problem, that seldom is the end of the story, because the reality is, and I know it's mediating, the example of somebody got the red bike at Christmas 30 years ago and nobody forgave each other, and here we are in court years later. It is, in my experience, a good one, because so often you think you've resolved something, you close a file, only to answer the phone a month later, and it's manifested in some other form. And I think the danger of seeking asking the court to resolve the current problem whilst it's attractive in some sense, particularly in terms of costs, you know, I think it's on us as practitioners to just have in mind that actually it's sometimes better to just go that little bit deeper, and that's when I think ADR comes to the fore and is sometimes something that actually provides a resolution rather than a disposal of a particular issue.
And presumably, I mean, the position's even more complex where there are family businesses involved, as there often are, as there was in the WONG case. I mean, most obviously top of mind, it's not just family members who are directors, but it may be a sort of proper old distraction for the whole board if they're trying to deal with the backdrop of the litigation, even if they're not actively involved. There might also be negative publicity and so on. What role do the lawyers have, perhaps even the trustees, in mitigating that, Charlotte? What do you think?
I think as lawyers, we have to have really early and honest communications with our clients about what is and isn't family business or for the family business, because I think so often you can see that the family business itself can end up becoming a pawn in the wider litigation or in sort of the disputes between the main protagonists. And I think that can cause fundamental problems at business level, particularly where you have got third parties and non-family members at board level or in sort of positions of authority within the business. It can end up isolating and alienating them and them finding themselves caught up in a wider war, which makes them feel deeply uncomfortable. And frankly, I think can to lead to a breakdown in relationships, and you can end up losing some of the company's best assets as a result. And so I think the lawyers need to be absolutely clear from the outset with their clients about what they can and cannot say in the boardroom. We've been talking about this in some of our discussions where we've seen clients sort of try and use boardroom dynamics as part of a wider power play between the family members and to put them in a difficult position, either by referring to without prejudice communications or comments that might have been made in a mediation to try and put pressure on other family members in the boardroom in a situation where they can't properly refer to those discussions or defend themselves in a meaningful way. And I think we all have a real responsibility both to educate our clients, but also to try and control them as best we can. It's not always possible, but it can cause real problems in the long-term future of that business if that's been allowed to happen as part of an existing dispute.
And I mean, I've seen situations where, in a trust dispute, one faction or another has tried to have someone removed from the board as part of, and it does not end well if you don't draw those boundaries from the outset, as you say. But Luke, so add some flavour to that from WONG. What else do we need to learn about family businesses and managing that fallout?
Yeah, I mean, I agree with everything that's been said. I mean, I think often the biggest risk in these family dynamics is that you have people wearing sort of different hats. So you'll get people who they might be the trustee, which is the shareholder. They might sit on the boards of the various companies underneath. They might also be an influential member of the family. And, ultimately, as a lawyer, you've sort of got to read through that morass of information and the sort of the complicated web of people and try and work out, what advice do you give your client? And I think a lot of the time it's much about reputation management as it is about being a lawyer and giving legal advice. And you've got to just have those two sort of skill sets together and sort of try and remember that this might be the biggest crisis that the family or the business or both have ever faced. And you've got to sort of navigate your way through that in whatever way is best for that particular family, whether it's litigating or some form of ADR.
I agree, and I mean, actually mindful of the fact that on a slightly different subject, but the Wagatha Christie trial is happening just down the road. I mean, publicity is something that nowadays, as lawyers, we kind of need to think about. I mean, it's possible, I suppose, that offshore courts might be more likely to hold hearings in private than the courts in England, but where wealthy families are concerned, do you see any kind of norm, Will? I mean, are they generally publicity shy, or are they very keen to fight it out as much publicity as possible with the Daily Mail in attendance? And what do you think?
I don't think there's any single answer to that. I think I've certainly had cases when the only thing, and I mean the only thing that the parties can agree on is that it should be all kept private. And equally, I've experienced cases where both sides are really determined to, make hay with bad publicity and, doing what they can to disperse the reputation of other family members. And I think, sometimes I think there's cultural issues driving one or the other, and sometimes I think there's just real kind of animosity and a sense of real wrong, that there's been real wrongdoing, and that the world should know. I think that what I would say on this is that, and I think Charlotte made the point earlier, that in these type of cases, you have to have these conversations very early on, because certainly, I think, you can't put the genie back in the bottle. Right? Once these statements are made publicly, everything becomes a lot more emotive and a lot more difficult. And I think at times when things are in the media or things have been said, it really takes, to the extent there is any pragmatism in the room, it really kind of evaporates quite fast. And it's hard then as practitioners to kind of get back to solving the problem that's in front of you and dealing with the underlying issues. If the perception is, well, however long this has gone on for and however much you tell me to be pragmatic, my brother is still phoning the Daily Mail or taking pictures of, sorry, we were so, taking pictures of family members. And I think it's really important that if you're involved in this type of work, that you do have that conversation early on, and that you do emphasise, how a reversible publicity like that might be.
Yeah, and I guess also sort of acknowledging those emotional issues with the clients as well, because otherwise it can turn into a sort of runaway train where people get more and more and more aggressive or determined to pursue the point right to the end. But thinking therefore about mediation and other forms of settlement, does this create push and pull factors for wealthy families in trust litigation? Are they more willing to reach a resolution in private, or does it make them less willing to do that? I mean, in my view, the emotional issues can sometimes get in the way because they need to be sort of somehow ventilated before that can feel like the end. And also, I think in many families of this degree of sort of wealth or sort of international interests, it can be the case that they don't care about the costs. And so that sort of factor, which can often encourage people to think about mediation as a means of limiting the costs, is a factor which is not really at play when you've got billions of dollars sitting in a trust that you're having a scrap over. Tell me more about your thoughts on that, Luke.
Yeah, I completely agree. I think it goes back to Will's example of the red tricycle or the red Ferrari, I suppose, and the height. And you've got these deep set grievances that have bubbled along for years, and it boils over into litigation. And to be fair to the protagonists, they often want their day in court because they want someone sort of independent and authoritative to tell them this is the right answer, this is the wrong answer. And yes, they don't care about the cost. And to be honest, they often don't care what the answer is. They care what the answer is, but the biggest thing is just having someone tell them what the answer is, whether it goes against them or it's favourable towards them. And I think often you can get that from a mediation as well. And I think a lot of clients don't necessarily appreciate that. And given that, it goes back to the cultural differences I talked about earlier, and there's this natural tendency in many places to do it all behind, you don't wash out dirty linen in public, you do it behind closed doors, you sort it out like adults. And you can't do that in a way that is still authoritative, because you've got a mediator there saying what they think. And that can give the clients the comfort that they think that they can only get from a judge down the road from here, for example.
It's very interesting. I mean, one possibility with some families is, of course, to tread that middle path in mediation and using mediation as a means of narrowing the issues or ventilating some of the emotional issues without actually necessarily accepting that the court cannot resolve those sort of issues, and therefore leaving trial on a narrower set of more focused issues. Do you see that at all offshore? And I mean, what role do the offshore lawyers particularly, but also the onshore lawyers, what role do they have in encouraging ADR, sometimes even against quite challenging circumstances.
So I think there are offshore lawyers in the room who will agree or disagree, but my experience is I think ADR is not top of mind for offshore practitioners. I think there are probably a number of reasons for that. Some of them historic. Some of them I think are a consequence of the issue we were talking about earlier, and the way onshore firms tend to use offshore firms. And I think as well, it's a case of the legal systems evolving to encourage ADR. I think I understand, although I'm not qualified to practice there, that the Cayman Islands are now moving in the direction of the courts promoting ADR. But aside from the kind of, whether or not the procedural rules and etc., these jurisdictions only have a small number of judges. So, for example, in the BVI, I understand Justice Jack, who's been there a number of years, is shortly coming back to this jurisdiction, will be replaced. If hypothetically he were to be replaced with a judge that's very focused on ADR, that's 50% of the judges in that jurisdiction that are then promoting this way of resolving disputes, right? And obviously that's something I would like to see, but certainly as things are at the moment, I don't think it's top of mind. And I'd make the point as well, just going to what you made the point earlier about the ADR or the courts both providing a resolution, because and the reason I just want to pick up on this goes back to the point we were talking about at the start of this discussion around collaboration and there being real collaboration between onshore and offshore. And I think offshore lawyers can only really make a meaningful contribution to the ADR or promoting ADR if they really understand the problem, the client's problem, and the root of the disagreement. So that goes back to my point about, everybody should be fully immersed in the case. And the other point, just to pick up on that as well, and it's applicable to both offshore and onshore, is you could, in these cases, have exactly the same outcome via a mediation or a judgment. But the advantage of the mediation is that you can frame that outcome as practitioners in a way that's far more palatable to both parties and actually might be the end of the underlying dispute, and everybody might leave feeling they'd had their moment, they'd aired their grievances, and they had an outcome that they're happy with. Whereas in monetary terms, exactly the same outcome from a judgment, where one party was told they were right and another one was told they were wrong, might have the complete opposite effect, and the dispute might go on. So I think, just to bring that together, to answer your point about, what can offshore lawyers do, I think, just being part of the team, explaining or discussing between onshore and offshore. Look, offshore, there's this, you may not have this onshore, but there's this gap in proceedings. There's 2 or 3 months here where not much happens. That could be used for ADR. Is that something you want to talk about? If so, we might need to make this application in BVI or Cayman, or even just as simple as discussing at the beginning of a relationship how stay in proceedings works. Which judge have we got? How are they minded to stay proceedings for ADR? Just, again, it goes back to the point I made at the start, but just really discussing it with one another and just having in mind that actually in a contentious family dispute, a resolution via ADR can be much more fulfilling for the clients because the practitioners can work together to frame it and present it in such a way than the same outcome might be from a judge.
Obviously, I agree with every word that you said. And also, I think that there is that absolutely crucial point that you made, which is a judge can only decide the issues in front of him, but mediation can be used to reach a settlement which brings in all sorts of other ingredients that might not actually be in front of the judge because they're impossible to quantify or explain in legal terms. And it's very interesting. But I think one of the issues here, and Charlotte, I really welcome your thoughts on this, is going back to the unique complexities of trust disputes. You're going to have the trustees, you're going to have the minors, the unborns, the future spouses. It can be quite challenging for the principal protagonists to realise that it's not just a question of them slogging it out in court or indeed doing a deal behind closed doors. There's other people involved.
I think the interests of the minors and unborns in any proceedings are often overlooked. And that what happens is that the principal protagonists think it's all about them, and that don't worry, they'll reassure their lawyers, we'll sort out the minors and unborns, they'll be well looked after, or they can have an interest in my trust, don't worry at all. And don't really want to hear about it. And think you might end up going down the ADR track and organising a mediation, and it's trying to ensure that those protagonists understand that even if they reach a deal at mediation, the minors and unborns, their interests need to be taken into account as part of those settlement discussions, because no agreement that's reached is going to be binding till it's been approved by a court on their behalf. The worst thing you can possibly do is go through a mediation or a WP discussion, not include representation for the minors and unborns, and then find that the whole thing just doesn't work and you've thought about it too late, having done all the hard work in terms of getting the protagonist to a mindset whereby they may well be willing to do a deal with each other. So again, it's just a question of ensuring that your clients really understand what every possible sort of permutation might look like, and that even when it's ADR, it's not that they have full control over the entire exercise. And for sort of high functioning wealthy people, that can be quite a difficult mindset to get their heads around, that actually there's going to be an independent representative here who may well have entirely different views as to how your children, potential grandchildren, might well be best served. And they need to be included in the discussions at an early stage. Often their input is extremely useful and actually can help unpick thorny issues, because they may well just have a different take on the dynamics, or they may well have some different suggestions as to how those minors and unborns might be protected. And so actually they can be quite useful, but equally for complex protagonists, they don't necessarily want to have that conversation at an early stage, but I think it's a really important one.
And whether the end is reached through mediation or a trial, we obviously can't end this session without talking about the other standout feature from WONG, which was the use of technology. So I want to come back to that. And indeed, of course, here we are today doing this session in hybrid format. And I'm very, very interested to hear all of your views on whether we're likely to see trials remaining virtual, or whether everything will be back to sort of where we were in 2019, early 2020. I mean, what do you think, Luke? Let's start with you and hear your thoughts, because you've obviously most recently done a
trial.
The
interesting thing about the WONG case is that the decision to go completely virtual was sort of forced upon us by the pandemic, so it wasn't planned. The parties and the judge were very keen to have a traditional in-person hearing, and it just proved impossible. And in many ways, the case had all the hallmarks of a case that you would traditionally think isn't suitable for a fully virtual trial. So it was very long. It had complex factual issues, very serious allegations being thrown around, very complicated areas, questions of law involved. Lots of factual witnesses, some of them very elderly, almost all of them giving evidence the aid of an interpreter. 5 or 6 different areas of expert evidence. The whole thing was just as complicated as it gets. And if you'd said to me in advance, this is going to go virtual, I would have thought there's no way we could, you're never going to get the experience of having the witnesses in the same room as the judge and looking into the whites of the eyes, and something is going to go wrong as well. And in the end, it didn't. And it worked pretty well, and it finished on time. I think we only had 1.5 days where there was a power cut in Bermuda, and then there was a power cut in Taiwan where all the witnesses were. And luckily we had some slack in the timetable, so we were able to sort of make up the time, and we finished bang on time as scheduled. So it is a great success story for complex international high value litigation done virtually.
It's amazing. I must say, my experience of the first few days of lockdown was the emergency move of a short trial online, and the judge was, as in those days, before everyone had had a great deal of experience of being online, the judge was very keen, very happy to use Skype, but he hadn't used it before. And so he sent an email around asking on the morning of the trial whether we could all do it with our cameras off. And that was absolutely fine. We were slightly puzzled, but it was fine. And we joined, and the judge began with the immortal words, "Ladies and gentlemen, good morning. I don't want you to think that I'm sitting here in my pajamas," which of course meant that we spent the whole of the rest of the trial imagining that he was sitting there in his pajamas. And so not everything, I imagine that all trials run more smoothly now. But I mean, there are lots of other factors in the advantages of virtual, and actually some disadvantages. Can we talk about time zones for a moment? And Will, I mean, you had experience. Have you had experience with this?
No. But I mean, if I could just pick up on one point from what Luke was saying, which is obviously in your case, the use of technology was mandated, which means that the message that conveys to all of the parties is completely negated. And what I would like to just emphasize the points I think is important in these family trust disputes is that if your client does or doesn't elect to, be in person or be on video, we need to consider not only what is best for our own clients, but the way that message is perceived and received by their opponents. Because particularly in one case I had where our client took the view genuinely that they thought the other side would all find it easier if it was all on Zoom. They wouldn't want to be in a room and all that, and it was we put forward the suggestion. The way that was received was the reverse, which was they can't be bothered to turn up. So I think now that we're in a world where technology isn't, as it was in an emergency situation, mandated by the court and is a really effective tool that does allow people to be in different rooms where that helps and is available to us, I think we just need to be mindful of the conversations we have, not only with our own clients, but with our opposing law firms, just about what is best for each case.
And the messages that might
and the
send.
messaging that sends.
It's really interesting. So, do you think we could end up with sort of hybrid arrangements, or does that look even worse in some ways? What do you think, Charlotte? If there are some people in the room and other people who have elected not to fly over from Hong Kong or Taiwan or wherever.
I think to a certain extent there have been hybrid arrangements for some time. In that I did a trial 10 years ago in the Cayman Islands, and we had some witnesses giving evidence by video link, largely experts or those who weren't sort of the key protagonists, but it kept cost to a minimum. It meant that we could stick to the trial timetable, and it had lots of advantages. And so I think there's a danger in overthinking these things as litigators. I think we can start to sort of analyze every point. I think sometimes you're going to be led by the judge in terms of whether or not the entire hearing is going to be virtual or not. I think you've got to do the right thing by your clients. I also think it's going to be the same with mediations. You're just going to have to sort of tailor it to the particular facts, the particular circumstances, the jurisdictions in which everyone is engaged. I think there is going to be more cost pressure, and from can you really justify everyone flying out in all these different sort of reasons just for the sake of it, and if it can be avoided. But I think ultimately the hybrid hearing is probably here to stay, and I think if you can, you don't need to justify an expert flying out to Bermuda to give evidence. That could probably be done remotely, and I don't think that's going to have a key impact. I do, however, think that the key protagonists need to be in the room, and I think I don't think you can underestimate the importance of body language in court and sort of reading signals, the conversations that you can have between lawyers who are all in the same building, and that actually you can catch someone on the way or in the way out and say, actually, there's just one point I wanted to flag, and have a conversation. That's much easier if you're all in the same place than it is having to sort of send an email and formalize a discussion. So I think there is still something to be said about being in the same room if it's all possible.
Yes, and I did hear an example of indeed a case where the parties, or one of the principal parties, was based in the Southern Hemisphere, and the trial was in the Caribbean. And so actually, in order to avoid time zone difficulties, the principal parties applied for permission during lockdown to come over here so they could sit with their solicitors and counsel. You look like you've got a question or a comment. Yes. Well, I can hear you very clearly, but...
Thank you. Hello, my name is Thomas Wolford. I'm an expert witness in investment and trusts, particularly offshore and onshore. I really wanted to look at not just the family disputes, which you've covered very well, but essentially what will happen with the amount of Russian money in trust structures, and how national governments may deal with that in the future, and whether this is perhaps just another nail in the coffin of offshore trusts as people try and penetrate the corporate veil, so to speak, or trust veil that offshore trusts have provided in the past.
It's such a super interesting point. You want to take that one on? I wish we had time.
There's a lot to unpack there, and I'm not going to try and anticipate government policy on what happens with Russian money. I think the point I'd like to make, and that does address your question, is the offshore jurisdictions, particularly the ones I'm familiar with, have a whole wealth of utility. It's obviously that there are trust structures which might hold, in your example, Russian money. There are also such a broad spectrum of other reasons those jurisdictions are used. And I personally don't think that there will be a kind of, I don't know the phrase you use, death knell in offshore jurisdictions. I think that there is a legitimate purpose to them. I think that the way they're perceived, there's points to that one might agree with, and there's points to that I think are perhaps hyperbole. And I think there'll be some changes, possibly because of what's happened in Russia and the fact that maybe there is Russian money there. I don't think that. I think that's such a small part of what offshore jurisdictions do that won't go anywhere near the extent to which you're referring. And just as a kind of anecdote, really, I was at the Offshore Alert conference 2 weeks ago in Miami, and somebody made a similar point, and a journalist kind of agreed and said, well, actually, do you realise there are journalists who use offshore vehicles to hide their identity whilst doing investigative projects so that they can report on Russian corruption, for example. Now, that's not a big part of what offshore jurisdictions do. I'm just saying that the conversation is much bigger than, is there Russian money, is there tax evasion? There are just such a broad scope of reasons, such a broad scope of reasons that those jurisdictions are popular and they provide such a broad range of services that I just don't think that small part of it will, maybe people like us will start to see more work as those trusts are unwound, but I think that will be the scope, the extent of it.
And those are relatively limited numbers of the kinds of entities that one might find in offshore jurisdictions anyway. I mean, I think it's not going to be a tsunami of cases. It's going to be a trickle, perhaps, of the more difficult ones. Anyone else with questions? I think we are very close to the end of our time, so I'd love to hear some questions. Please, go ahead.
Just picking up on the question raised there, I'm Rebecca Attry from IPOS Mediation, also a lawyer. And I think one of the really interesting areas for us to look at as lawyers is bilateral investment treaties and investor-state claims, and whether actually where you've got states that are seizing assets, then whether an investor can bring a claim. So I'm looking at family businesses who've got investments in certain states, and then it's in Russia and you've got the seized assets, and whether you've actually got war clause in the bilateral investment treaties, and can you then bring claims in that way? And I think there's going to be a real increase in that, and I think that is going to be an interesting aspect, and it will be interesting to see how that will relate to the question of offshore trusts, because many of those offshore trust jurisdictions do actually have those bilateral investment trade treaties.
Thank you. Very interesting. Hetty, looks like you've got a question.
I just wondered, in relation to these long-running, highly emotional disputes that you've been talking about, as advisors, how do you ensure that you don't get dragged into the emotion and the personal animosity of the disputes and keep that professional distance?
Very good question.
It's a very interesting question, because there is, I mean, of course, as everyone has been saying, you have to understand at least the emotional kind of context to the whole dispute, and you have to recognise that there are really two disputes going on, as we were saying. Who wants to pick up on that? How do you stay above the? I
think not everybody does. I think you just have to remind both yourself and your team, but also your clients, that every letter you write is potentially going to be read by a judge.
Yeah.
And just because they want you to write a certain type of letter, threatening everything under the sun, making all sorts of allegations, that's not actually necessarily going to serve their best interests. And I think that can be a difficult conversation, and clients don't necessarily want to hear it, because some clients quite like the tub-thumping letters, but it's not necessarily going to further their cause or actually ultimately work in their favour. And I think lots of lawyers find that really difficult. And I think it's part of our professional responsibilities actually to try and rise above some of the emotion and actually try and separate fact from fiction, and actually where the law is really going to take the particular case. But it's not always easy.
Anyone else?
Thanks very much. Sean Tracy from Campbell's in the Cayman Islands. Not so much a question, but a few observations from our own experience dealing with trust disputes. And I'll just mention them briefly. The first of all is, I think, is the choice of leading counsel can be quite important. And it would be a mistake simply to choose a specialist trust barrister from the UK necessarily, because sometimes the issues involved are much broader. They're fraud related, there's freezing injunctions, there's cross-examination. And sometimes the trust barristers are pretty woeful at cross-examination in comparison to a more generalist commercial litigator. The second observation would be that local offshore counsel can assist not only with the advice, but with the relationships. So, for example, within the trust structure, there may have been a freezing injunction, there may have been independent receivers, independent directors appointed throughout the trust structure, the companies. And it might be the instinct of onshore lawyers, to send a stiff letter to the receivers if they don't agree with their course of action, whereas the offshore counsel might say, well, let me send him a WhatsApp, we'll have a lunch and we'll discuss it. And therefore, you might, in fact, get a better result as well as maintaining the relationship and goodwill. The third observation is about funding. If there is an injunction in place over the trust assets, for example, and yet the trustees need to defend litigation that's seeking to set aside the settlement, then really they've got no option other than to seek a variation of the injunction. But that probably will not be granted if it's a proprietary claim, and therefore they'll have to look at litigation, third-party litigation funding. And the downside for the beneficiaries of that, of course, is that if the trustees succeed ultimately, then there's likely to be a very hefty success fee payable from the trust assets to the funder. And you can bet that at some point, the beneficiaries will complain about that as well as everything else. Just finally, I speak with another hat on as the secretary of the Chartered Institute of Arbitrators in Cayman, and which is a fairly recent chapter. It's true that ADR in Cayman has historically been rather lacking and backward compared to England. That is changing gradually. We're seeing an increase in arbitrations, and we're also, as an institute, trying to promote ADR more generally, including mediations. But you're right, the starting point is still some way behind.
It's very interesting. I mean, just picking up on your point about choosing the right lawyer. I mean, I think one of the great things about offshore trust cases is they are often fought like big, scrappy, comlit matters. It's all about cross-examining the other side. But then there's all these really technical legal arguments and, oh, that's all very well, but what about this case from 1723 that's got this really nice chancery point? And you've got to get the right team to do that. And as I said earlier, you don't want lots of different lawyers coming from different perspectives on the same question, because then what does the client do? But equally, you've got to find the people who can work together well and bring the right skills to the table and just, work out the right answer, looking at it from all the different points. I think that's hard to achieve in some cases. In our case, we did achieve it, I should add. But, yeah, very interesting. Thank you.
And much as I would love to continue, I think sadly we are about to lose our audience members from Zoom. And but please, if you have any other questions, let's stick around and have coffee, and you can ask any of us for our thoughts on things or share your own experience. Thank you very, very much for coming along today, whether in person or by Zoom. And we've very much enjoyed it, and I've hugely enjoyed having such a fabulous panel. Thank you.